Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law. Today we're going to talk about 11 situations in which you should consult your business attorney. The first is incorporation. I'm usually the first point of contact for my business clients because before they can open up a bank account, they need to become incorporated. There's a couple benefits to incorporation. One is liability protection, so you want the liability of the business to be limited to business assets. The other that a lot of people don't know about is you can save on self-employment tax by being incorporated versus by operating without a corporation. So you should talk to an attorney about the benefits of LLCs versus corporations, whether a corporation is right for you, but most importantly, for people who want to do it on their own, the problem they'll run into is that they don't set up their corporate formalities like bylaws or meeting minutes for shareholders properly. And if you don't do that, then if you ever get sued, whoever's suing you can pierce right through the corporate veil, that's the legal term, for basically saying your corporation's a sham, you haven't been following corporate formalities, and get to your personal assets. So we want to make sure that doesn't happen, and that's why it's important to talk to an attorney or an accountant, some professional, about incorporating properly. The second situation in which you want to talk to a business attorney is annual maintenance. So if you incorporate, you've got to file an annual report with the Secretary of State. And in order to maintain those corporate formalities we were talking about earlier, you need to do annual meeting minutes of shareholders and directors and provide proper notices, even if you're a sole shareholder. So that's important, again, because if you ever get sued and you don't have those, your corporation's not going to protect you. So talk to an attorney about annual maintenance, and it should be an automatic thing. It's not expensive, and it's something where we just get your signature on a piece of paper saying that these meetings happen. The third one is a biggie. That's when you start hiring employees. Your biggest source of litigation or disputes or problems are going to come from disgruntled employees that you terminate and they think it's wrongful termination, or they think you're breaching the employment agreement that you have with them. But an attorney can help you make sure you've got a good employee offer letter, employee handbook, employment agreement, that you've got workers' compensation insurance, and you're aware of other pitfalls like the workers' compensation requirements and registering with the Illinois Department of Employment Security before you go into hiring employees. We can also help you make sure that if you do need to terminate an employee, you won't be paying unemployment tax premiums that are higher than they should be. If you terminate them quickly enough and have a probationary period, you won't be on the hook for unemployment tax. The other thing that you want to watch out for is paid vacation and time off. If you structure the contract properly, you can have that accrue over time. And if an employee leaves after 2 weeks, you won't be paying them 15 days of paid time off immediately. Number 4 is anytime you have a business relationship with anyone, you're going to want a contract in place, and you're going to want that contract reviewed by an attorney. A couple situations that are pretty common are your lease, any vendors that you work with on a regular basis, independent contractors, agreements between your partners. If you're purchasing another business or the assets of another business, you're purchasing property, you need a good contract for those. And even if the other side has a contract that they're ready to have you sign, you should have that reviewed by an attorney. Again, it's not expensive, but the disputes that happen if the contract is ambiguous or poorly drafted are expensive. And those disputes usually only happen if there's something wrong with the initial contract. So having an attorney review your contracts can save you a lot of money down the road. Number 5 would be investor agreements. So if you've got a great idea but you don't have the capital to execute it, or if you need the capital to execute a growth strategy, you might want to bring in outside investors. And rather than just issuing them shares, you're going to want to talk to an attorney to make sure you have a properly structured agreement with those investors before they actually come into the business, so that everybody wins in that situation. So number 6 is trademark and copyright. There's a lot of pitfalls with this, because if you have a great business name and a great business logo and you start doing business, and 5 years down the road someone has their attorney contact you and says, hey, we had a trademark on this and you're in violation, you've got to change your entire branding, which is going to be expensive. You're going to lose customers. It's going to be confusing for people. So if you're the first to file the trademark registration for your name or your logo, that won't be a problem. You're on record as being able to use that name, and if someone else tries to confuse customers by using something similar, you can stop them from doing that. Copyright, anytime you've got a great idea, a software you've created, anything in writing you've created, so a book, a handbook, basically anything that's put down into paper or some other solid form, you can copyright that and prevent other people from stealing your intellectual property. Number 7 is dispute resolution, litigation, and collection. So I put dispute resolution and litigation into separate categories. Dispute resolution is something that happens before litigation, and it's the process of trying to prevent litigation from happening. Litigation can be very expensive, so our philosophy at our firm is to try to resolve problems with a carrot rather than a stick. We still want to get a good outcome for our clients, but if we can avoid them getting involved in a court case and paying us a lot of money in legal fees, then they're going to stick around as a business client for a long time. So it's important to us and to our clients to resolve any disputes before litigation that we can, because if you can pay $5,000 to someone who's threatening you to go away, that's better than paying that same $5,000 to an attorney to defend the suit, and then maybe still having to pay the person that's threatening you with litigation. If it does come to litigation, it's good to work with a firm that has both a business attorney and a litigation attorney. They're very different areas of practice. I've done both business transactional work and litigation work in my career. I focus now on business transaction work, but I always make sure that I have a great attorney in my firm who's a bulldog, so that if things go to litigation, they can fight for the rights of my business clients. And finally, collection. It's great to have a lot of invoices to issue to people, but if they're not paying them, your cash flow is going to be hurting. So usually I'll work with my clients to have a good internal collection process so that they don't have to share any of their revenues with a collection attorney. So that involves having a good process of calls and letters to send, threatening collection, and having late fees built into your contract with your customers. And that goes back to number 4, contracts. You should always have a good customer contract that allows you to enforce it. So if someone doesn't pay you, there's some threats you can make, like late fees, like collection, like getting your attorney's fees paid if you do have to go into collection. And if you're not able after 90 days to collect the accounts receivable, that's when you bring an attorney in, and usually if you file a complaint in court, that case will settle and you'll get your money paid, and hopefully all of your attorney's fees as well. Number 8 is, if your business is in distress, you should talk to an attorney to see what your options are. So there's a lot of options other than just closing up shop. One of those options is negotiating payment plans with your creditors that allow you to make payments over time, prevent them from filing suit against you to collect those payments, and allow you to have the cash flow to both meet those payment plan obligations, but also still meet your other obligations as a business and hopefully still make some money on your business to keep it solvent. If that's not an option and you've gone down that road and tried it, then there's other things we can do, like filing bankruptcies, or if you've set up your corporation properly, if you've done your planning at the outset, winding up your current corporation and continuing your business with a new clean slate in a new corporation. Number 9 is exit strategies. So the business brokers I'm friends with tell me that you should start thinking about your exit strategy right when you're setting up your business, even if it's going to be 20 years down the road, because no one's going to be doing business and working in their business at 105. At some point, you're going to need to either sell your business or transfer it to a key employee or a family member, and you don't want to wait until 5 years before you're ready to do that, before you start planning for it, because if it's going to be a gradual transfer, like a profit-sharing program, you might need a good 10 or 15 years to put that in place if you're not just outright selling your business to a third party. Number 10 is estate planning. So if you're in business, you have probably some sort of complex estate planning that needs to happen. It doesn't need to be terribly complex, but you need to figure out how your trust or your will is going to interact with the shares of your business, and that kind of goes into an exit strategy too. But if something were to happen to you, what's going to happen to your business? Is your spouse going to run it? Are your kids going to run it? Or are you going to have an agreement in place with someone to take your client base and pay your family out? That goes into exit strategies, but you should also have an estate planning attorney that works either with your business attorney or is the same person, because there's a lot of interlocking interaction there, and your estate plan needs to incorporate your business plan. And finally, business consulting, number 11. I'm a business nerd, and that's really come in handy for my clients. I have another podcast called seizeyourbusiness.com where I just talk about business issues and try to find ways to make businesses more efficient, more effective, and come up with growth strategies. And I really think that it's a benefit to clients to have an attorney that's actually also a business owner, and also cares about non-legal issues in the business. Someone you can grab a beer with and talk about the struggles you're having or your big ideas, and discuss how to, from a legal and non-legal perspective, effectuate that. And it should also be someone who can provide resources to you, like bankers, financial advisors, accountants, and insurance people that they work well with, to come up with a cohesive strategy for your business as a whole, not just the legal issues. So those are the 11 situations in which you want to consult a business attorney. Please don't hesitate to give me a call. I offer free consultations, and my phone number is 630-324-6666. And if you want to hear more about different areas of law, more about business law, you can find more of these videos and audio recordings at learnaboutlaw.com. And you can also find a written form of this presentation at learnaboutlaw.com. So please check it out. Thanks so much.